afternoon, everyone. I request everyone to keep their phones in silent, and if the honorable bench permits, we can proceed. So, I request the petitioners to start.
Sorry, addresses as addresses as no lordships.
Council is appearing before the Honorable Court in the matter of the Gaskali Institute and Young People Leaders versus RBB Ola, RBB Kalyan Puri, Consortium of RBBs, State of Gola and the Union of Indra. On behalf of the petitioners under Article 136 of the Constitution of Indra. Sirs, there are three main issues involved in the present case. The Council will be dealing with issue number 1 and issue number 2 that are regarding the maintainability of Article 126 and 159A respectively. Subsequently, my co-counsel will be dealing with issue number 3. Council seeks permission to begin with the brief summary of facts. RBB Tola introduced 55% horizontal reservation for the domiciles of Tola on 10 March 2023. The Gaskali, a non-governmental organization managing a food center which teaches mostly students with limited financial capabilities, filed a writ petition under the Article 226 before the High Court of Tola, challenging the validity of the order issued by RBB Tola. Kautilya Taksila Institute filed a writ petition in the High Court of Himagiri against RBB Tola, but was asked to withdraw the same under the argument that RBB Tola does not come under the jurisdiction of High Court of Himagiri. So, Kautilya Taksila Institute approached the Supreme Court of Indra under Article 126 of the Constitution. RBB Kalyanpuri also introduced a similar 55% domicile reservation which was challenged by young legal leaders in the High Court of Vijayanagar, which repeated the former state order on the issue. As a result, young legal leaders appealed against this at the Supreme Court of Indra. They also prayed that the Supreme Court may withdraw the similar placed cases from the respective high courts and transfer the case to itself and decide the validity of the domicile reservation of all the RBBs. The Supreme Court issued a notice to RBB Tola, the consortium of RBBs, the state government of Tola and union government of Indra. All the petitions have been listed for 4th June 2023 by the administrative wing of Supreme Court of Indra. Now, the judges are well acquainted with the facts of the case. The council seeks permission to proceed with the pleadings. Much obliged. Sirs, the first issue is whether the special leave petitions against the order of the High Court of Tola, Vijayanagar and Himagiri, filed with Vyasali, Young Legal Leaders and Kautilya Taksila Institute are maintainable under Article 136 of the Constitution of Indra. Vyasali first filed a writ petition under Article 226 of the Constitution of Indra, which is a provision that grants power to the High Court to issue orders, directions and writs before the High Court of Tola, challenging the validity of this order. It is argued that since Rashtrapati Vishwavidyalaya, as per the name suggests, have acquired national character and conduct national entrances already pan-Indra, any reservation based on domicile would dilute this character. Moreover, many students of Vidyasthali were originally the residents of Tola and have passed the class 10th board exams from the school in administrative limits of Tola itself are not eligible for this domicile reservation as they shifted to Vidyasthali and hence given the exams from the school, given the 12th board exams from the school situated in Vidyasthali, which is in Kurukshetra. The students did not even get time to switch schools since the board exams were held at the same time when the new notifications were issued by the respondents, as they did not announce the reservation during the general body meeting of the consortium of RBBs. For the mentioned reasons, it can be inferred that the immune order is allowed to be in operation. It could cause irreparable loss to the students by jeopardizing their future, as the students enrolled at the Vidyasthali came from poor families. For them, as well as for the students in the as there is no other RV in the neighboring states. Your Lord, your Sirs, the petition seeks for of this honorable court to be granted appeal against the order of the High Court, as the High Court of Thola erred in granting interim relief against the order, as it effectively suspended the rights of the students to have access to education. Similarly, young Indian leaders, they are aggrieved by the order of the High Court of Vijayanagar, which vacated its earlier stay order against the notification of 55% of self-reservation issued by R.V. Kalyan in 2023. If the new order is allowed to be in operation, it would cause similar irreparable loss to the students of Vijayanagar, the same faced by the students of Vidyasiri, who are affected because of the impairment and inability suffered by the issuance of this order. It is respectfully argued that the High Court of Kalyanpuri erred in vacating its earlier stay of the High Court order of the notification of 55% reservation issued by R.V. Kalyanpuri in 2023. Therefore, the petitioner prays to state that the new notification transfers the remaining cases to itself involving similar substantial issues and adjust upon the question constitutional validity of the new notification. When the petitioner reported that the Institute approached the High Court of Margari, they asked the petitioner to withdraw the petition and approach appropriate forum due to the reason of R.V. Thola being situated beyond the territorial limits of the High Court of Margari. Your Sirs, as observed in the case of Naval Kishore Sharma versus Union of India, the Supreme Court under Article 226 Clause 2 stated that indisputably, even if a small fraction of cause of action accrues within the jurisdiction of the court will have jurisdiction over the matter. Therefore, it is appealed in the High Court. The High Court has urged in the decision in denying to exercise its jurisdiction under Article 226 Clause 2 of the Indian Constitution, which says that the petitioner has the ground to approach the High Court of Margari as being aggrieved party representing the residents of the state, raising sufficient cause of action for the exercise of such power. Under Argument 1.1 of Issue 1 on page 19, the respondents have wrongfully claimed that no substantial and grave injustice has been observed by the High Court. In fact, it is not for the High Court to observe grave injustice. Rather, as per the exercise of Article 126, this is at the discretion of the Supreme Court. To further support this argument presented by the petitioners, your Lord, Sirs, please refer to page 16 of the memorial, where the Supreme Court has not only observed that relief can be granted in special circumstances that are of substantial importance and to grave injustice, as in the case of freedom versus the state. The Supreme Court has also observed in the case of Rajabhai Abdul Rahman Mushi versus Vasudev Dhanjibhai Modi that the powers exercisable by the court under Article 136 of the Constitution enable the court to interfere in a case where an irreparable injury has been made or can be caused, just like what the students, especially those who hail from weaker economically weaker backgrounds throughout India, will face by the issuance of the order of 55% of self-reservation. Further, in Delhi Judicial Services Association versus the State of Gujarat, the Supreme Court has held that under Article 136, the Supreme Court has wide powers to interfere and correct the judgment and orders passed by any court or tribunal in the country. To conclude, it is humbly submitted before this honorable court that the special relief petitions against the order of the High Court of Thola, Vijayanagar and Himagiri have met the essential ingredients required for the maintainability of Article 136 of the Constitution of India. If the Lordships are satisfied with the pleadings of the issue, I will constitute permission to begin the issue. Much obliged. Issue 2 is whether the Supreme Court of India should remand all the matters pertaining to domicile reservations at RV from the respective high courts and decide matter together. It is humbly submitted before this honorable court that under Article 139A of the Constitution of India, the Supreme Court has the power to remand all the matters from the respective high courts and decide the matter on its own discretion. The written petition filed by Vidyasali under Article 226 of the Constitution of India before the High Court of Dhola challenges the constitutional validity of the order, argues that since many students in Vidyasali are original residents of Dhola and have also passed the class 10 exams from schools in Dhola, they would still not be able to apply with the domicile reservation as they have appealed for class 12 board exams in Kurukshetra. Similar petitions were filed before the High Court of Jammu and Kashmir and Uttarakhand, which were edited by the respective High Courts and are pending adjudication. The petition and young legal leaders pleaded before the High Court of Vijayanagar against the notification of R.V. Kalyanapuri introducing a similar horizontal reservation of 55% for the candidates of the state of Vijayanagar. The matter is submitted for the time being. It should be further considered that the above-mentioned petitions pending before the respective High Courts concern the issue of public interest and the issues are substantially similar in nature. The executive orders virtually suspend the rights of the petitioner and deprive them from access to education. It would be expedient for this court to transfer the case to itself to meet the ends of justice. It is submitted that it is an apt case for the court to exercise the power under Article 139A, read with Order XLI Rules 1 to 5 of the Supreme Court Rules 2013, and withdraw the cases from the respective High Courts and dispose of all the cases by itself so as to avoid multiple interpretations of law and settle the law at once. As it can be seen in the case of AR and Chule versus R.S. Nair, where the Supreme Court has held that Article 139A encourages the interstate transfer of cases, that is, from a court in one court to a court in another state, or the withdrawal of a case by the Supreme Court itself. If the lordships are satisfied with the proceedings of the issue 1 and issue 2, Council 60 Commission to opinion that the issue 3 which will be headed by the Board Council.
Alright, please tell me before you start. Please tell me, you use 3 words: remand, transfer and withdrawal. What do you want the court to do? Right? Second thing, please also address me. How does it impact the poverty? You said the poor families, students belong to poor families. How will this domicile reservation have impact on poverty? There I want to be enlightened.
Much obliged for the question, sir. The first, the petitioners want the Supreme Court to transfer the cases from the multiple High Courts and take the matter to itself and decide whether the domicile reservation is valid or not. For your second question, it affects the poor families of other states as well as the 45%. Sorry, not the 45%, but it affects the poor families from other states of the that surround Dhola and Vijayanagara, as the 55% domicile reservation does not ensure that the reservation is made for economically weaker sections in the that there are economically weaker sections present inside the domicile, as there can be rich people who have acquired the domicile, because vertical reservation already exists in all the RVBs throughout India, but making a domicile reservation does injustice to poor families that do not belong to Dhola or have not passed the class 10 and 12 board exams in Dhola itself.
You read your page 9, para 3.
Yes, sir.
Page 9, para 3. Read that. Vijay Sthali provides free coaching to the selected. Are you the same thing? You want to say?
Yes, sir.
Read that. Is that the answer? Read loudly.
Vidyasali provides free coaching to the selected students and takes care of their overall expenses and accommodation. They further help the students in preparation for the class 11th and 12th examinations.
So they are the poor people.
Yes, sir.
These poor students who have the Vidyasthini itself is talking about the fact
Other than Vidyasthini, there are many students who want to achieve a seat in RBB Thola and as well as RBB Vijayanagara.
that answers the question.
Okay.
That is the answer to the question.
Okay.
That the people who are, the students who are coming up,
Yes.
they belong to that poor state of society. And they will be,
Achha, nice.
eliminated out. And on the first question also, you have to make a distinction between what is the difference between demand, withdrawal, and transfer. So what does Article 139A uses the word? Article 139A uses the word transfer or withdrawal because demand is, all these three have different word content.
It uses the word withdrawal of the cases.
139A. 139A is transfer of certain cases.
It uses transfer of certain cases. To explain it, can I
The Supreme Court is on the
read
top.
139A?
The Supreme Court is sitting on the top.
Yes, sir.
Supreme Court, demand is normally made to the court below. When you are sitting on the top, then you can transfer to yourself
Yes, sir.
or withdraw.
It is 139A does state that it is referring to transfer of certain cases which involve the withdrawal of the cases
Transfer
from the
is
multiple
from,
times.
say suppose transfer can be from one court to another.
Okay, sir.
Withdrawal will be to itself.
Okay, sir.
And the transfer can also be to itself because the withdrawal, the whole process is ultimately
It
on
withdraws
it further down.
cases to itself.
Then the entire record will be brought from there. And then the Supreme Court itself will decide.
Yes, sir.
The real issue you have to understand is each word is a word.
Apologies on my part, sir, for that confusion.
No,
One
we
point
also
of
we
time,
also learned this
don't
from
apologize.
No, at one point of time, you had used the correct approach. Transfer to itself.
Itself.
You had used those words, and those are the most appropriate words.
Okay, sir. Thank you very much, sir. Can we begin with the show?
And the legal issue, I'll tell you, the legal issue is basically you have to show that how a petition is and the 136 is maintained. I think you missed that idea. And the 136 because it says from any court you can call petition, especially petition. And we discussion 136 I you must have read 136 itself. Article 136. So that real question is why 136? So real issue is maintainability. Why is it maintainable? You have to just show why it is maintainable. That's it.
Article 126 of the Constitution of India grants the Supreme Court the power to grant special leave. And special leave can be filed in a case where a substantial question of law arises that, or it does some grave
You have to
injustice.
show what is substantial question.
Substantial question is that throughout the RBB, the domicile reservation has been made inside RBB Thola and RBB Vijayanagara right now.
Substantial question is that reservation is valid to Article 14. The Article 14 talks of equality
Yes.
and reservation is creating a fissure in this equality.
My co-counsel will be taking his answer.
Okay, sir.
I am trying to open your mind. The whole idea is to help you to open up your mind.
I understand, sir.
So that
I
you
understand.
can, open up your mind and think.
I am very thankful.
The whole law is thinking on your legs.
Yes, sir.
Don't get uncomfortable.
Very good.
You must continue to think on your legs. And you fight with your brothers, sisters, and mothers and parents. So that's the way you have to start thinking. But in law,
You must actually stress one particular thing. Why are you before Supreme Court? Number one, why? And why 136? You went to High Court first, you know. You have marshaled the facts. You know that you have gone to the High Court with a specific request, specific prayer, that this be stayed. And what was the take of the High Court? Doesn't matter. It is intervention comes from our side.
so 226 are relevant. 220, you should not deal with 226. You should go to 136 straight.
226 was
Not
a
important. Because we are
Vidyas
dealing with-
filed earlier. It
Right.
was
But today you are dealing with 136. You are not dealing with 226. That's the error. Okay, let's see.
Please.
Much obliged, sirs. The council seeks permission to introduce the third issue. Much obliged, sirs. The third issue is whether the Act of RBB Thola extending 55% horizontal reservation to the the candidates is violative of Article 14, 15 and 21 of the Constitution of India. Now that sirs are well acquainted with the third issue, the Council seeks permission to begin with the arguments. Much obliged, sirs. The Act of RBV Thola states that all the students who cleared their class 10 and 12 board exams in the administrative limits of Thola are eligible to apply in RBV Thola under domicile reservation. This is violative of Article 14, 15 and 21. Sirs, the Council will be dealing with Article 14 first and 15 and 21 respectively. Article 14 of the Constitution of India states that the state shall not deny equality before law to any person. RBVs have attained an extremely strong sense of national identity over the years. They have been a crucial part of all the students wishing to pursue law. But with the introduction of the domicile reservations by RBV Thola, the national identity of the RBVs has been hindered to a remarkable level. Furthermore, as many students have moved to Vidyasali after clearing the class 10 board exams from Thola, they are not eligible to apply under the horizontal reservation as it appears for class 12 board exams from Gujarat. This creates a barrier between the students who gave both class 10 and 12 exams from Thola and those who only gave class 10 exams in Thola, even though all of them originally are residents of Thola. Sirs, the Council will be obliged if you refer to page number 20 of the Council's memorial for further reference. In similar previous cases like Vijay Goyal and others versus the state of Karnataka, the Supreme Court clearly stated the suppression of the excellence or skills of the candidate and benefit of one's residential status, that being of mere relevance for admission into a good college on the basis of merit and capabilities. Advanced forward, in both cases, the Supreme Court held that inter-state reservations in universities of national importance are unconstitutional. Besides, it defies the sense to create more reservation in the state when the reserve is already granted, as the socially disadvantaged citizens of Thola already have enough representation in universities across India. Sirs, for further reference, the Council requests you to refer to page number 25 of the respondent's memorial. Page number 25 of the respondent's memorial. On page number 25 of the respondent's memorial, issue 3.1, submission B. The Council takes care of a test enshrined in the precedent state of West Bengal versus Anwar Ali Sarkar about the quintessence of reasonable classification. Sir, Madam Judge, the question. I am not very versed with the facts because this was the respondent's memorial and I just saw it. Madam Judge, sir. In the precedent state of West Bengal versus Anwar Ali Sarkar about the quintessence of reasonable classification as propounded by the Supreme Court. It is because of that very reason that the reservation would have sufficed and would have passed the test of reasonableness if it had been below 50% and would have still upheld the student's fundamental right. Because there would have been an equal division between the domicile students and the general category students. But now it has 50% reservation policy. But now it has passed the 50% reservation policy. So an unequal division of seats is visible, which is hindering the fundamental rights of the non-domicile students. Thus, the Council submits the repeat order as the violation of Article 15. Article 15 states that the state shall not discriminate against any citizens on grounds only of religion, race, caste, sex, place of birth, or any. The domicile reservation introduced by RBV Thola was not to give equal chances to the weaker segments of society. The criteria of this reservation was the economic background, the educational background, rather it was the residential status, making it hard to ensure that the students getting a seat under the domicile reservation did not belong to any weaker segment, as they can easily be from a very strong economical background, In the case of Jagdish Saran versus Union of Indra, it was clearly stated that exceptions in favor of only the parts of a society that are discriminated against may be provided in the case of admission in state-owned or aided educational institutions. It is hence submitted that the impugned order has been violated of Article 15 of the Constitution. Article 21 of the Constitution states that no person shall be deprived of his life or personal liability except according to procedure established by law. As per the ruling of Mohini Jain versus State of Karnataka, the right to education is to be included in the right to life. The students of Indraprastha had the option of only RV Thola because that was the only good law school in the neighboring states. Further, some students gave their class 10th exams from Thola but 12th from other states, depriving them of being able to apply under domicile reservation. These students are deprived of good education, causing them irreparable loss, lack of access to education, that is jeopardizing their future, thus violating the right to life. Honorable Supreme Court has also observed that legislation could be invalidated on the grounds of constitutionality if it lacks legislative incompetence and manifest arbitrariness. The Council seeks, it is therefore submitted to declare the challenged order as being violated of Article 20. The Council seeks permission to begin with the prayer. Therefore, in the light of facts explained, issues raised, arguments advanced, reasons given, and authority cited, this court may be pleased to adjudge and declare that the special leave petition against the order of High Court of Thola, Vijayanagar, Himagiri, filed by the Vidyasari young legal leaders for Taylor Tashishila Institute, may kindly be accepted and relief for others may kindly be given in favor of the petitioner and against the respondent. It is further prayed that the Supreme Court of Indra shall remand all the matters pertaining to domicile reservation at RVs from the respective high courts and decide the matter by itself, looking into the facts and circumstances of the case. It is further most respectfully prayed that the order by which RV Thola and RV Kalyanpuri extended 55% horizontal reservation to the candidates be quashed for being violated of Articles 14, 15 and 21 of the Constitution. And further grant any other relief that the Honorable Supreme Court may be pleased to grant in the interest of justice, equity and good conscience. The Council is grateful for such a patient hearing, sirs.
See, you read Article 14. You can go to the same page.
Yes, sir.
Page 25. Like it. Read like.
Can you take the 6?
I have the Council will.
Because this is what you are reading.
You read, no?
Uncle is not in my.
I know I'm not talking about authority, I'm talking about principle. Legal. You have to understand the legal.
Page number?
25.
So there is no page number 20.
You can have it.
The Article 14 has got two principles. You understand the principle. One is there should be a reasonable classification. Reasonable classification. And then whatever has been done, here what is the classification?
Domicile in the domicile reservation, the classification is whether the student has passed class 10 and 12 board exams from the
The
state.
classification is between the people who have got reservation and people who have not got it. So the classification is between the people who are coming on merit, but there is still a group of people who are entitled to reservation. So that is the classification. That is the classification now. Now the second part is there has to be reasonable classification. The second part is the classification should have a nexus with the object. Now what is the object sought to be achieved by education? The education is that by education the person must serve the country. Now whether this that classification has got any relationship with that or not? Yes or no?
Not like, sir.
You have to challenge that, you have to say that there is no relationship.
Not like, sir.
classification is unreasonable.
Yes. Yes.
And it has got no relationship with the object which is sought. Your object is excellence. And Article 15 is place of birth. There's nothing, you can't classify the place of birth. 14, 15, it is violating Article 14.
Yes.
At Congress, you have used the word view order is violating of Article 48. What do you actually understand by view order? And which is the order which is imputed for us, the Supreme Court of India? Which is the imputed order?
Much obliged for the question, sir. The imputed order here is the order by which the RBB Rola and RBB Kalyanpuri argued to practice nationalization.
That is basically notification. That notification has been challenged. You went to High Court. The order passed by the High Court can be said to be imputed order. But that order would not be violative of Article 43 or the notification issued by those RBBs are in fact violative of Article 43. So be careful with respect to that choice of word. Imputed order is the order which is otherwise passed by the High Court. You have not come under Article 32 of the Supreme Court of India. You are under 136. So you have to challenge some order or the other. That order which you are challenging here is the order which is passed by the High Court, whereby you do not have to stay.
Much obliged, sir.
Yeah, understanding facts is not just knowing the facts, you understand the facts.
The council seeks permission to refer to the bench collectively as first. If the council is well versed in the facts of the case, the council seeks permission to begin with submissions under issue 1. Much obliged, sir. Am I audible now? The council humbly submits that the special leave petitions against the order of the High Courts of Dhola, Vijayanagar and Himagiri, filed by Vidya young legal leaders and Concordia Takshila Institute, are not maintainable under Article 136 of the Constitution of India because no substantial or grave injustice has been observed by the High Courts. A special leave petition filed against any judgment, determination, sentence or order of the lower court is granted where the court is satisfied that there has been a grave miscarriage of justice and it requires correction. The Supreme Court was meant to exercise its power under Article 136 sparingly and in exceptional cases only. The council humbly submits that in the factual matrix of the case, no grave injustice has been observed by the respective High Courts in the denial of the stay order or in the overall conduct of the High Courts. The introduction of domicile reservation for the people of the state is justified and a common practice. The reservation notified by RBB Dhola and RBB Kalyanpuri is not uncharted territory or grave injustice by any means. So there is no reason to dilute the binding nature of the extensive precedents and jurisprudence that already exists on such matters. The council humbly submits that my learned friends have not presented how a substantial question of law exists in the case before the honorable bench. As stated in Sir Chunni Lal Mehta and Sons Limited versus Century Corporation, if the question is settled by the highest court or the general principles to be applied in determining the question are well settled and there is mere question of applying those principles or that the plea raised is palpably absurd, the question of law would not be a substantial question of law. Hence, it is the humble submission of the council that the bench relies on the well-settled extensive precedents, point and jurisprudence established under the Apex Code, such as in the case in D.P. Joshi versus State of Madhya Bharat, reiterated in Dr. Pradeep Jain versus Union of India, D.N. Chanchala versus State of Mysore, Dr. Dinesh Kumar versus Motilal Nehru Medical College, Anant Madan versus State of Haryana, and Rajdeep Ghosh versus State of Assam. The Council pleads that the bench applies those principles to the current matter as they are established on sound and elaborate judicial reasoning. Therefore, the Council submits that there is no substantial question of law. Article 226 of Clause 2 talks about territorial jurisdiction, which the Council pleads must be considered with respect to the doctrine of sub judice and the doctrine of forum convenience. According to the doctrine of sub judice, there aren't supposed to be two high courts adjudicating on the same issue between the same parties, and being aware of the fact that the other court, namely the High Court of Dhola, had already listed the petitions to be heard. The Council submits that there has been no error by the High Court of Himagiri in asking the petitioners to approach an appropriate forum. It is further submitted that appropriate forum was not intended by the High Court of Himagiri to mean the Supreme Court. Rather, it is more reasonable that the appropriate forum in this case was Dhola High Court, since the territorial jurisdiction point has been emphasized. The Council for Petitioners, in stating the grounds laid under Article 226 in Naval Kishore Kumar vs. Union of India on page 16 of the Petitioners' Memorial, have taken it out of context. In the same case, it was stated that we must remind ourselves that ever if a small part of cause of action arises within the territorial jurisdiction of the High Court, the same by itself may not be considered to be a determinative factor compelling the High Court to decide on merit. The Council also submits that there has been no error in the denial of relief in the form of a stay order. The ground essentially filed by the petitioners is primarily against the denial of the stay order by the High Court of Dhola and the vacation of the stay order by the High Court of Vijayanagar. However, the basis for the grant of interim relief is that the balance of convenience must be in favor of the plaintiff. That is, the court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused to the parties if the injunction is reversed, and compare it with that is likely to be caused to the other side if the injunction is granted. The Council humbly submits that in the grant of the stay order would lead to a more substantial injury to the respondents in comparison to the petitioners. It is further submitted that the grant of interim relief in the form of the stay order would cause inconvenience to all Arland aspirants, including but not limited to the students of Dhola and Kalyanpuri. The entire student body residing in the administrative limits of Dhola and Kalyanpuri would be arbitrarily left out of the admission process. An extensive amount of obstruction would be caused to timely admission procedures, as many students choose the university in order of preference. Hence, granting of the stay order would deprive a large number of students from getting timely admission to the university of their choice. Moreover, granting interim relief in the favor of petitioners would cause considerable disruption and hardship in the administrative machinery of Arland, RV Dhola, and RV Kalyanpuri. It is also submitted that the notification of Arland has been withdrawn and revised once, and doing so will cause unreasonable chaos and disruption at the administrative as well as the student level. It cannot deny that a large amount of miscommunication chaos initiate if the prospectus has to be filed again. In addition, the Council humbly submits that there is no absence of a alternate notification system and hence no notice to the Apex Court. The petitioners have filed their SEC based on the denial of interim relief by the High Court of Dhola and as established by the Council, the petitioners do not have ground to claim interim relief. So since there is no difference of opinion between the High Courts on the grant of stay order and they are united in their denial of interim relief, therefore the matter has already been decided by competent judicial authority. Moreover, since the respective High Courts have admitted the writ petitions under Article 226, the petitioners should wait for the decision of the High Courts about the validity of domicile reservation, which is yet to be given. The High Courts of Dhola and Vijayanagar are willing to hear the submission of the petitioners, and the hierarchy of legal recourse has to be respected. It is generally expected that the appellant has exhausted all other sources the law provides before approaching the Apex Court. Moreover, the High Courts of Jammu Khanda and Uttarajya have stated that the matter at hand is within their jurisdiction and are willing to adjudicate. Both the High Courts have issued notice to RV Dhola and the consortium of RVPs. Hence, the Council humbly submits that the respective High Court should be given a chance to adjudicate on the facts of the case. The Council has concluded its arguments under issue 1 and seeks permission to proceed with the submission under issue 2.
Please tell us, there are different High Courts, same issue pending there.
Court in the grant of the stay order. Earlier, the High Court of Vijayanagar did grant a stay order, but it was vacated when the facts of the case were further submitted.
But that is, you said substantial injustice.
Yes, sir.
136.
Yes.
Where is the word substantial?
Sir, it was established on the basis of the extensive precedent that is binding.
Injustice.
The word, read from the language. It says
The council acknowledges this.
Notwithstanding anything in this chapter, the Supreme Court made its discretion grant special leave to appeal from any judgment, decree, determination, sentence or order. So there is an order. There is a stay order. Vacation of a stay order is also an order. In any cause or matter made by court or tribunal in territory. So why is it not written in it?
Much obliged, sir. The
And
council.
part 2 also, notwithstanding one shall apply to judgment, decree, sentence, and law related offense. So one, you see, 136, one is that you accept substantial injury which is not there. Secondly, it is an order passed by a high court. It's covered. Why is it not maintained? You are on the maintainability.
Much obliged, sir. The council humbly submits that the council acknowledges the decision power of the Supreme Court, but it pleads that the Supreme Court should consider that there is no statute by question law, and hence the High Court should be allowed to adjudicate on the matter. It is the plea.
Can you please elaborate on what was the question of law and what was the substantial question of law? Once you say that there was a substantial question of law, what will be the basis? What was the substantial question?
Much like that, sir. The council submits that there is no statute by question law because there is already settled precedent on the case. So it is not the first time that the case has been brought. Domestic reservations are in fact have been contended with the court before. There is settled jurisprudence on the matter. Why is the Supreme Court settled? So there is no substantial question law because the lead party.
What is the distinction between a question of law and a substantial question?
But this is a very smart argument. There is no question of law, much less substantial.
What is the distinction between a question of law and a substantial question? That's what it is. Because 139A talks of, 136 doesn't say. But 139A talks of substantial question. It's pending in different high courts.
Much
What is the
obliged, sir.
distinction? That is what my lord
Much
was asking
obliged, sir.
about.
The council submits that the substantial question of law is a question of general importance.
So it becomes, if one high court says that reservation is valid, other high court says it's not valid. So is it not a substantial question of law for Supreme Court to step in and adjudicate?
Much obliged, sir. The council humbly submits that that is yet to happen. But the high courts have not even been given a chance to adjudicate in the
There
matter.
are 4 high courts dealing with the same issue.
But there is no difference of opinion in the grant of the stay order. And the validity of domestic reservation is yet to be questioned in the high courts. The legal recourse is not expected.
So you mean to say that Supreme Court should wait till there is a conflict of interest decision amongst the high court and then Supreme Court should. Like your argument is
Like the police waiting in the office.
Much obliged, sir. The council humbly submits that is not going to be the case because extensive precedent by the Supreme Court is already present. So when talking about presumptions, the council would like to submit that there is going to be no difference in the grant of about the domestic reservation by the high courts. The council is very confident about that because there is settled precedent in the case by the Supreme
What
Court.
we are
which is
saying
why
is the question of law or the substantial law, the question of law is already decided by the Supreme Court. The High Court are bound to follow it. So why they should come to the Supreme Court?
Much obliged, sir. Much obliged, sir. The council humbly submits that although settled precedence is there, the council is looking at the high courts are looking at the facts of the cases right now. And as established by the Supreme Court, the Supreme Court did not grant interim relief, which shows that the Supreme Court is convinced that there is no urgent question of facts in the case. And earlier, even when Vijayanagar did grant the stay order. It was vacated when the hearing was observed for further.
The other issue is not a case of balance of convenience. Just to give you the thought. The main issue is once a certification exists, it is deemed to be valid. It is deemed to be valid. So no court can should grant a stay unless there's some evidence of good law. There is a distinction between regular intention of the balance of convenience issue. Here the validity of a notification is challenged. And all the statutes are basically held to be valid unless they are struck down. So till they are struck down, they are valid. How can the High Court grant a stay to a statute? That's the line of argument we use.
Much obliged, sir.
And supported by Kameshwar Singh way back in 1950s.
I missed that, sir.
The judgment of Kameshwar Singh, when they held for the first time, that once a statute or an amendment or any statute is there, it must be held to be valid till it is struck down by a court. And you can challenge. But by challenging the validity, you can't grant that should not interfere with the provisions of the statutes.
Much obliged, sir.
Just one thing as why this is the resolution based on the system should be applied. One most important reason is accordingly. And whether in the outcome of this resolution are you not compromising with the academic? What is the reasonable nexus? What do you want to achieve?
Much obliged, sir. The Council submits that the domicile reservation should be amended because the state has power to provide domicile reservation. And as for the merits of the case, my co-counsel would be initially.
So you are representing whom?
I'm representing respondents. The council.
Who are the respondents?
It's RVP Dhola, RVP Kalyanpuri, Consortium of RVPs, State, and Union of India and
Who is
others.
representing Union of India and what is the take of Union of India on this? Or whether they are on your side, Union of India is also with the state universities.
Pardon?
Who is representing any one of you?
Yes.
You are representing Union of India. So Union of India is in complete synchronization with what you RVV say.
Yes.
So the stand of RVPs and Union of India is same. This is what you want to say. Union of India is also no objection to this, or Union of India has some different opinion.
Much obliged, sir. As if now the council submits that
You understand the line? What he's saying is, since Union of India has supported you by making grants and all, are they supporting you or they are against you? You should say yes, they are supporting
Yes,
you.
they are supporting
Why
us.
hesitate about saying it?
they are. I was making sure that I understood the question. The council seeks permission to proceed with the submissions under issue 2.
No, that is
Much obliged, sir. The council humbly submits that the Honorable Supreme Court of India should remand all the matters pertaining to domicile reservations in RVPs and respective high courts and not decide the matter itself. The state has power to provide domicile reservation. Since the state is spending money for legal education and procedure.
If you remember the last time, the question was remand. So you remand to the High Court, their Supreme Court under 139 is transferring them to themselves. So the word remand is normally when you give it to the lower courts. We are not talking about remand here. In fact, there is an error in the whole term. What the 139A says that they can withdraw it to itself if the substantial question of law is pending in different high courts.
Much
What you have to say is that the Supreme Court should not transfer the matters to itself.
Understood, sir.
And why should they only do? Because then you go back to your own argument, which you already made. So you can make that argument.
Right, sir. Understood.
Make that argument. Let's see.
Council's permission to proceed. Much obliged, sir. The state has the power to provide domicile reservations since the state is spending money for legal education and procedures of the university. And there is legitimate interest for the state in ensuring that benefits flow to its domiciles. It is not unreasonable that it should order the education system that the advantage of it to some extent ensure the benefit of the state and its residents as quality appended chose versus state of Madhya and reiterated to Dr. Dilip Chair, this is Union of India, Anand Lal was state of Haryana and Rajdeep was the state of Assam. Moreover, RVP Dhola was the creation of the state legislative assembly State Legislative Assembly Act, 40 out of 60 acres of the university's land has been provided by the state of Gola. People from Gola are paying taxes which fund the university. Hence, the council contends that it is justified for the state to ensure that the people of Gola are able to give the benefits of the institution, since it is reasonably rich that the money which would otherwise be spent on the education of the children elsewhere should come back to the state. Even if World War I, that is created for the nation, 25 RVs have been set up for ensuring high access to high quality education in the respective states where they are situated, just to ensure access to these institutions to the people from different regions of the nation of India. The Council has determined that the consortium of RVs act as a body to ensure system of checks and balances within the RVs, just like the judiciary in case of the legislature and executives. For instance, the consortium expressed dissent in the RVs Gola's shortcoming in getting the women prior to the order, ensuring that it was protected by RV Gola by extending the deadline, hence proving that it is much like the judiciary, a non-partisan body. Both RV Gola and RV Kalyanpur's reservations were approved by the consortium. The council's status, the consortium status as a national level board, which ensures the proper function of 25 RVs, must be taken into account. The council would like to enforce that the matter is not maintainable because, as already elaborated in issue 1 by the council, there is no defensive opinion in the grant of stay order, and they are united in the denial of duties. The matter has already been decided by competent judicial authorities. Moreover, as elaborated in issue 1, there is no such unquestioned law in the reservation policy introduced by Pitula and Kalyanpuri, as there is already settled jurisprudence on the matter. The council also humbly submits that, as previously stated, the judicial competency of the judges of the High Court must be held in due consideration. The petitioner should respect the High Court's legal wisdom. They should not think of the High Court as a mere forum to approach the court. Instead, they should wait for him to exercise their authority to declare their judgment on the writ petition filed before approaching the Ethics Court. The council thereby rests its case under issue 1 and issue 2 and seeks permission to
When you talk about competence of High Court judges, then in that case there should be no Supreme Court. High Court judges are very competent. But should there be something about Supreme Court also? Supreme Court also not be always competent.
The council thinks that in this case, 4 High Courts have been approached. As now,
That's what our previous query was, that there is a possibility of conflict of findings. Existence of conflict of findings may not be necessary. So to rule out that possibility, Supreme Court wants the matters to be withdrawn, what is wrong in it?
the High Court, the hierarchy of legal recourse has to respect. The Council again acknowledges the discretionary power of the Supreme Court, but humbly submits that it should only be exercised when there is substantial question of law. In this case, there is the competent judicial authority, mainly the High Courts, have exercised their jurisdiction and plan on doing so about the validity of domicile reservations as well. But they were not given a chance, because as soon as the decision on the stay orders was put out, the petitioners approached the Supreme Court, and the competency of judicial authority, the High Courts, was not really taken into consideration.
But if you read 139A, I think the statutes must be read clearly well. 139A very clearly says that where a case is involving the same or substantially the same question. Substantially the same, not a substantial question of law. One or more High Court or 2 High Courts. The Supreme Court can refer to this.
Master Digest, sir. The Council again acknowledges this discretionary power of the Supreme Court, but contends that there is no need for it, because the High Courts are competent judicial authority, and there is no substantial question.
I suppose we agree with you and we don't transfer the other matters to ourselves. What about our 136 petition? That this can be done, and suppose we give any indulgence in that specially petition, then what would be the impact? Because the order coming from the Supreme Court, don't you think that would be automatically question of law ultimately remains the same. So other high courts may, taking cue from that order, may also ultimately pass the same order. Then where would you find yourself? So it's always better that if the question of law is same, all such matters should be decided by the same judge.
Your argument should be that you decide 136 and don't bring all the matters to Supreme Court. Then 136 is legally decided. Let me put up the more and let me heard, decided and all the like. So I got to go to Supreme Court. Why should I be the court and all that? So many lawyers come, so many problems will be there. 136 should be decided. One matter. That's all.
Greetings to the bench. The Council seeks permission to address the bench collectively as serves. The Council seeks permission to begin with this submission under issue number 3. For the purpose of coherence, the Council would like to dissect its arguments under Article 14, 15 and 21. The Council requests the bench to turn to page 25 of our memorial for your convenience. Beginning with Article 14, the Council submits that the reservation introduced by the respondents is intra-biased and not violative of the provisions contained under Article 14 of the Constitution. The Council, just like your Lordships, would like to begin with doctrine of presumption of constitutionality laid down by a 5-judge bench in Sri Ramakrishna Dalmia versus Justice S.R. Tendulkar. That is, the constitutionality of a statute is to be presumed, and the burden to prove contra is on him who asserts the law. Article 14 prohibits class legislation, but it permits reasonable classification. For the classification to be reasonable, it must satisfy the 2 criteria laid down by the State Supreme Court in the case of State of West Bengal versus Anwar Ali Sarkar and reiterated in R.K. Garg versus Union of India as follows. Number 1, the classification must be founded on intelligible differentia which distinguishes those groups from the others. And second, the differentia must have a rational relation sought to be achieved by the object of the act. The Council hereby submits that the reservation is based on intelligible differentia. The differentia behind the creation of the domicile is to distinguish between the residents and non-residents of the state by according admission to those students who have passed their 10th and 12th examinations from a school which is located within the administrative limits of the respective states. The Council presents that the reservation notified by the respondents is merely a separate and exclusive channel of entry. The Council would like to clarify that the reservation is provided only at the stage of entry and not within the universities. This means that even if the secondary university is admitted, they must improve their standard and acquire the same proficiency as any other candidate by passing the examination within the universities. The Council further submits that the classification has a justified object sought to be achieved. The first object of the reservation policy is to ensure that the residents of the respective states get adequate access to the educational institutions which are located within the geographical boundaries of their own states. It is also submitted that merit is of greater consequence when it comes to super specialty and postgraduate courses. As held by the Supreme Court in case of Jagdish Saran versus Union of India, it is stated that the higher the role of specialty, the lesser the role of reservation. In our case, it is submitted that the level of specialization is negligible. The Council would now humbly request sirs to turn to page 25 of the petitioner's memorial. Permission to proceed. My learned friends have misinterpreted the judgment of Indraprastha versus Union of India by saying that the 50% cap upheld in Indraprastha applies to the same case as well. The same has also been done in the case of has been submitted by the petitioners in the case of M.R. Balaji as well. The Council here would like to establish that there is a distinction between horizontal and vertical reservation, and the judgment in the said case of Indraprastha was with respect to vertical reservation, and the same does not apply to the factual matrix of the above case which concerns horizontal reservation. The Council would now request your sirs to turn to page 20 of the petitioner's memorial, where they have cited Vijay Goyal versus State of Karnataka. it is humbly submitted that the councils have submitted a case which concerns postgraduate reservations. However, under the factual matters of the said case, it concerns undergraduate reservations created by the state.
What difference will it make undergraduate or postgraduate?
Much obliged, sir. The difference between a reservation under postgraduate and undergraduate is always of merit. The level of specialization required in undergraduate courses is negligible because the students are just at the stage of entering. In postgraduate courses, they have already studied enough. And as said in the case of Jagdish Saran, in such cases, merit has to be given value. But it is submitted humbly that in our case, the prevalence of merit is negligible. And it is to ensure that equal access is provided.
There is a distinction between vertical and horizontal reservation.
Much obliged, sir. Reservation for scheduled castes, scheduled tribes, and other backward classes is referred to as vertical reservation because it applies separately for each of the groups which are specified under the law. However, horizontal reservation refers to equality of opportunity provided to other categories of women, such as women, transgender community, in our case domicile, cutting across vertical categories.
Within the 55%, you will have a reservation for women.
Much obliged, sir.
This is right? When you got this year, you have got 55%, 45%. This is called horizontal. But within the 58%, you will have reservation for women, you will have reservation for Lulnas, tribes, and other PCCs.
Much obliged, sir. Much obliged, sir. The council, in fact, would like to take the help of your observation and reiterate that the vertical reservation and horizontal reservation includes and spans vertical reservation as well. It would ensure that the educationally backward classes, the scheduled castes and scheduled tribes are given double advantage and more preference in the said district. It furthers the argument of the council that the vertical reservation is also accommodated within the horizontal reservation. Permission to proceed?
Only one thing. You say that the level of specialization is negligible. What do you actually want to convey? Because if a student passes out from your argument, he will be a law graduate. And that is the bare minimum qualification if one has to practice in wherever, whether it's High Court or Supreme Court, provided that he also has the requisite qualification regarding policy. Then why do you say that it is negligible kind of specialization? It is rather the only bare minimum. The postgraduate doesn't mean that you automatically become eligible to practice in superior courts. If you are law graduate, simple law graduate, that is enough. Then why do you say that it is not that special kind of qualification?
Much obliged, sir. The council would like to clarify that what the council intended to say is that the level that creating reservations at the postgraduate level is different than creating reservations at the undergraduate level. The same argument further in this case was that in postgraduate reservation, the students entering have already done, as you stated, a law degree. So if they are proceeding for their masters, they have already acquired a degree of specialization by their law degree. So in the said case, in the Jain versus Union of India, as well as the recent was held, that creating a reservation or preference at the postgraduate level would undermine the role of merit, which is more important at such levels. However, in our case, it is the undergraduate level, and the role of merit is not as relevant as compared to postgraduate. The council seeks permission to proceed. Second objective of the reservation policy is to ensure equality of opportunity by circumventing the fallacy of merit by preventing underprivileged people who are educationally handicapped, socially disadvantaged, familiar or structurally handicapped from availing the benefits of the quality educational institutions established in this space. Meritocracy, being a competent measure of someone's aptitude, is a myth. In reality, it is measured by who has more money. Hence, it is some merit that the reservation created by the respondents ensures that the less privileged people get a chance to take away from the capitalistic chokehold that the rich have on the economy by getting admissions to the best of schools of India. Moving ahead, the council submits that the classification as a rational object with the rational nexus of object. RPP Bhola and Kalyan cases Reservation policy has been accused of injustice and arbitrariness prevailing worldwide. But merit in itself is subjective, which is determined by the resources at one's disposal. The root of the problem is primarily a lack of access. It is hereby submitted that we must ensure that the gap between the legal equality and practical equality is bridged by increasing access to education. The Council would also request the respective service refer to the judgment in Justice Saran on page 30 of our memorandum. Permission to quote. In the first place, it would cause a considerable amount of hardship and inconvenience if students residing in the region of a particular university were compelled to move to the region of another university for medical education. Moreover, some difficulty would arise in the case of births, because if they are not able to get admission to medical college in the place where they reside, they might find it difficult to pursue medical education in a college situated in another region where the hostel facilities are not. And even when they were available, their parents may be hesitant to send them to services. The Council would also like further submit that the domicile reservation has a reasonable nexus as satisfied the object of providing access. The reservation policy is stated to a larger set of problems by creating a horizontal link and handicaps discussed earlier by the Council creating inequality. Hence, making it a constitutional obligation on the state under Article 14 of the Constitution to ensure that the section of the society which has been marginalized and handicapped is given a fair representation.
Tell us something to mention we are wondering. This was a meeting in 1986 that a woman may find it difficult to go to other state and pursue education there. Is this kind of an argument in today's age will it not be regressive? Today the woman is traveling across the globe every day.
Much obliged, sir. The Council acknowledges the fact that women have progressed in the world and in our country as well. However, the concept of patriarchy still prevails and women are still suppressed, thus making it constitutionally obligated on the state under Article 15(3) to create separate domicile reservation for women and children. It is also submitted that there are still regions which are backward in nature, or the concern of safety of women is still a big one, which makes parents who want their daughters to get quality education scared to send them to other states.
You just pick up your submission.
Much obliged, sir.
Last part. So you say, your father has been in the
Yes, sir. Sir, yes, 1951. Yes, sir.
But then you go to your this
The propositions.
and go to page paragraph 12.
Unlike RV Kalyanpuri, the RV Yoga did not discuss the proposed reservation during the general body meeting of the consortium of RVs, and this reservation was not even mentioned in the prospectus and notification of the budget.
It is not discussed and it is not in the prospectus. How can this due association of laws?
Much obliged, sir. As my co-counsel really pointed out, that the said case is not of illegality, however of an irregularity. In the case of Maneka Gandhi versus Union of India, it was held that post-decisional hearings are also valid, and it hereby submitted that the irregularities are some which can be corrected, and it was corrected.
Maneka Gandhi is not only about post hearing. When you are talking here at page 42, let me tell you. See, Gopalan said 14, 19 and 21 are vertical, so you can't read one into two. In Maneka Gandhi, they say this is a golden triangle. So you have to read 14, 19 and 21 together. So in that way, your procedure should also follow the principle of protocol. It should be, and anything which is arbitrary is anything which is not unreasonable, unjust and improper. That is what the language is. Is violative of 14, but it is arbitrary. If you have not, para 12, if you have not followed this, you are not even mentioned, you don't have the authority to do it. The authority is not there and the procedure is also not followed. Para 12, it is very clear. That means the 15 did not hold. And somebody just passed an administrative order and it will give you a consideration. Whether this is related or not.
Much obliged, sir. The council would like to address this when it gets to submission under Article 20. Or if it's satisfied, if it summarize the argument as well. Shall I summarize? Much obliged, sir. As I already said, submitted by my council, there is a difference between irregularities and legality. It is acknowledged that the irregularity was observed by RBP. However, the same irregularity was corrected by getting the reservation approved by the body of consort. And an extension was also given for 15 days to the application assessment. So the said irregularity has been corrected, and the due procedure of law, which says that it must not be irregularity, is also observed as due application of mine, and the discernible principles of justice have been followed by citing, as the court cited, extensive precedent in various cases. Hence it is submitted that due to the consonance between Article 14 and 21, any provision which is not violated by Article 14 must necessarily be interpreted by Article 20. The council seeks permission to proceed. The council now seeks the second part of the argument under Article 15. The reservation criteria it is submitted does not amount to discrimination on the basis of place of birth in the Article 15 subclause 1. It is using the outstanding judgment of the Supreme Court in the case of Singh versus State of Madhya Pradesh. The council would like to state that the distinction was created between place of birth and domicile. It was said that it was elaborated that the economic meaning of domicile must be considered. The same was observed by a high judge bench of the Supreme Court. It is humbly submitted that said judgment is fine. The same has also been reiterated in multiple judgments such as Dr. Gobind versus Union of India, Saurabh Chaudhary versus Union of India, and tried extensively in Anand Pradhan versus State of Haryana, etc. It is also submitted that creation of separate domiciles for different states is not violated of Article 52.
Moreover, case of Article 12, where they say whether the petition will lie against an institution.
Much of that, sir. In the case of Pradeep versus Union of India, the domicile criteria must have satisfied two conditions for it to be valid. One is of regional backwardness, and other is of state interest. In Dr. Pradeep, it was observed that state interest has already been upheld under D.B. Joshi versus State of Madhya Pradesh as submitted by my co-counsel. As the regional backwardness is concerned, the council humbly submits that even though the state of Bhula is the capital of Indra, it accommodates within itself people who come from ethnically diverse regions of the states, different states of Indra. Also observe in the case of Jagdish versus Union of India, with respect to Delhi, which is the capital of India, it was held that the reservation criteria created for Delhi students must not be considered arbitrary, because the state of Delhi compromised within itself people from different states. The council seeks permission to proceed. When we speak of a person as having a domicile of a particular country, the person is governed by law of that country. Domicile has reference to the system of law by which a person is governed. But it might as well happen that the laws related to succession and marriage might not be the same all over the country, making it therefore quite conceivable that there should be different domiciles for different states. The council would now like to begin with submission under Article 21. Under Article 21, the council submits that in the case of TMA 5 was Foundation of the State of Karnataka, it was held that the right to education, higher education, is not incorporated under Article 20. It is also settled provision of Article 21A that there is a right to education must be accorded to children from ages of 6 to 14. The reservation policy by RBBs adheres to the procedure established by law as already submitted by the council. The council now seeks permission to begin with this prayer. Therefore, in light of the facts reasons given, authority cited, this court may be pleased to adjudge and declare that special leave petitions against the order of High Courts of Bhola, Vijayanagar and Himagiri, filed by Vidyastali, young legal leaders and Kautilya Dakshina Institute are not maintainable under Article 136 of the Constitution. The Supreme Court of Indra shall remand all the matters pertaining to the domicile reservations to the respective High Courts, and it is pleaded that it shall not decide the matter itself. The final plea is that the claim of the petitioners should be held unmarried, holding the reservation criteria created by the respondents intra vires and not violative of Article 14, 15 and 21 of the Constitution of India. And any further grant of further relief that the Honorable Supreme Court may be pleased to grant in the interest of justice, equity and good conscience, all of which is most respectfully submitted by the counsel for the respondents.
The council seeks permission to approach the vice for the rebuttals.
Yes.
Much obliged, sir. The council seeks permission to begin with the rebuttals. Much obliged, sir. The first rebuttal is, the respondent have said that the High Court orders have not led to great injustice of any sort. Could they specify how exactly providing a horizontal reservation of 55% to an institution, hence a layer of vertical reservations already exists by keeping meritorious candidates at bay would not lead to any injustice of any sort? The second rebuttal is, as stated by the respondents, particularly Rajvi Dhola, they are well within the rights to extend reservation to domiciles as the land on which the institution's campus was built was procured by funds collected by taxes. However, taxes are compulsory payments which are unilateral in nature. Hence, there is no compulsion on the state of Dhola to create an act for the residents of Dhola on the basis of tax-paying nature. Then how is RBV Dhola well within the rights to extend reservation to domiciles? The other rebuttals would be there by the co-counsel. The council's permission to pass through to the other council.
Much obliged, sirs. The further rebuttals are, the respondent have provided a domicile reservation of more than 50% without providing any quantifiable data as to why a domicile reservation of such a degree is needed in the first place. The Supreme Court time and again in various judgments has cited that the states have to provide a justifiable reasoning and elaborative data as to why they are extending a reservation to a particular section of society. The last rebuttal is, as stated by the respondents, if merit is not relevant in undergraduate courses compared to postgraduate courses, why is the National Entrance Exam RLAT conducted to check merit? Thank you, sir.
You want us to set aside the orders of the High Court, and also you want us to withdraw the proceedings before us. So if we have to withdraw the proceedings before us, where is the need to set aside those orders of the High Courts? We will be deciding it ultimately.
Much obliged, sir. I do not understand the question. Could you please
I
repeat?
repeat,
Yes.
you have sought two things from us.
Yes, sir.
You say one, set aside the order of the High Court.
Yes, sir.
Second, you say that we should withdraw all these pending disputes before us and then decide. So if we have to withdraw and decide, then there is the need to set aside one order. Because once we set aside that order, we are setting aside that reasoning also.
Much obliged,
And
sir.
tomorrow we may be in agreement with that reasoning.
It is, it will do justice to the petitioners if you consider the orders of the High Court after withdrawing it, and if you come to the same agreement, that will be honoured by the petitioners. Before that, there should be a consideration again by the Supreme Court as repeated by the petitioners time and again.
The answer is that once you file a special leave petition, it is only a petition. Once the petition is admitted by the Supreme Court, it becomes an appeal.
Okay, sir.
Now, after the appeal has become and all the matters are transferred, then the order will be set aside. They are not setting aside today. They will be set aside at the final hearing So once they come to the conclusion that 55% reservation is incorrect, when they struck it down, no division has to be struck down. Then the High Court stay order, that not granting of this stay will also be struck down. Everything will go. But what one thing is everybody should learn is to, when you do it, the statute, if you are reading 136, you must read 136 and every word of it. 139A and read 139A. Read 14, read 15, read 20. Then read it and try to think on your own. Then go to the judgment. You see, number of judgments cited here is amazing. But I don't think anybody has read the whole judgment. It is just one line from here and one line from here and one line from there and one line from there. So that doesn't make good reading. That doesn't make good readings. And submission also, it's very, it's too elaborate. It's too much of cut and paste situation. I know this is a way of the young generation is doing it. But if you continue to cut and paste and don't absorb it, see, you have to feel Article 14, that equality issue. What is equality in fact? Then only you will be able to argue well. Then you will see justice being done to your guys.
And one more thing, students, don't get bogged down by the questions which we are putting to you. It's a beautiful field. You people know much more than we know. So do some more work. Join on this site, come in law profession.
More you get back, better it is. But very dignity. Always maintain it.
The council correspondence is the provision for surveillance.
There is a provision for server, but I'm really
At the
adamant for
decision
that.
of your sirs.
Let's hear them. Let it be like to be heard. But then one point was raised regarding quantifiable data. That is an issue which has been raised in the scientific study. Why should people? That should have been your first point.
Yes.
I don't know why you reserved it for joint.
Much obliged, sir. The council would first like to collectively address rebuttal number 1 and 4 of the petitioners. By retaliating the fallacy of merit which has already been said, the petitioners asked us why we do not let our lad prevail and let merit decide the case. It is because, looking at the practice of entrance test, it is the rich which get privileged under the concept of such entrance tests. Because
That's not a fair argument.
it's not a fair argument. The council submits that only rich have access to proper educational institutions, coaching, resource materials, basic resources,
The
etc.
person in Vijayanagar Para 2 itself, you say that the person is giving the coaching. He is a very well versed, there is a very well established coaching center, and they are giving to the most poor without any charging anything. So you can't put that, you can't say that only the rich get the best and the poor don't get the best.
So you are giving 55% reservation for those who are having domicile of your state. So are you having any upper income cap of their parents also? So the rich would automatically be
Eliminated.
don't get the
Eliminated. You say only the OBC of the 55% will be taken up, something like that.
Much obliged, sir. However, the council submits that considering an income cap would make it under the purview of vertical reservation, hence amounting to similarity on economically weaker sections.
You have 55% horizontal and 50% vertical. So simple. There's a fallacy. Arguments are tested when you stretch them. When you stretch them to its logical conclusion, then you will see whether your argument stands to the logic or not. When you say that this line between rich and poor, the only argument is that Para 2, where he says that he is coaching there, and those people who are being coached who belong to a lower section are being affected by that, because they may not get admissions. So that is the only argument that you can have. You can't make that line, bring Marxism to divide between rich and poor. Don't do that ever.
Much obliged, sir. Thank you.
What about quantifiable
What
data?
about
Much obliged, sir.
Did you do a research on quantifiable data?
It is submitted by the council that data or demographic information was not taken into account, could not be taken into accountability. However, there is a justifiable explanation for the 55% domicile reservation. It is just 5% above the 50% cap to ensure that adequate representation can be given to the people of the state under this the council would also like to state the State Reorganization Act of 1956, where Pandit Jawaharlal Nehru, ex-Prime Minister of the country, apprehended that dividing the states on linguistic basis would disintegrate the nation and undermine the unity. What in reality happened was the linguistic minorities got the respect and belief, and the unity of the country was upheld and strengthened. Similar line of reasoning will be reiterated by the council by saying that if such a
All your states are based on linguistic minority. All your states, Gujarat, Gujarati, Bengali. Ultimately, you feel like, unlike America, where you had perfect straight lines. India did not develop on perfect straight lines. We went on the languages. The linguistics were there as a part of the division process. How do you say that what Nehru said, he implemented?
The council would like to submit that it was due to the protests which happened in Andhra Pradesh that
But I am unable to correct it with quantifiable. But anyway, I am also happy that very good toy is there. If you can't correct it, it's confusing.
much obliged. Much obliged. The council will thank you, sir.
After the Advocates Act, there are only advocates in India. There's nothing like council. Typically, the word council is British. They have what they call the King's Council, the Queen's Council. You see the cases. In India, we have got senior advocates, their essays. So I think we will get out that British legacy and stop using the word council at all. But they submitted it enough. And when then also you don't have to say. You make your submissions. See, the issue is nobody is stopping you to making this. You have to come out with your submissions. You don't have to again and again. Because that, that break the thoughts. You don't have to say that council. You are submitting. And one of these, they are very small things. People normally they say, give me 2 minutes more and something like that. Why should you? You just say, who is stopping you? You must be absolutely focused, straight. It's like focused like Arjun. That's what you are. And besides, but you have to do, I don't know, the error in the word demand itself was wrongly used. And then legal research that you have to make, you don't do it without understanding the fact. Nobody really went deep into what is the reasonable classification and what is the unreasonable. And then what is the excessive objective is not classification. It is immediate submission. Excess is the object of it. Here what is the object of it?
what is the objective of the benefit to the local people? How does that relationship come together? So dealing with the different scientific, you have to be very clear about the fact. Like Mother Sarkar was basically, and this entire law was really developed in the Army Darkness. And after Army Darkness was followed in the special code of reference. Nobody did it. Army Darkness is, they laid down 7 points on Article 14. And then special reference in 78 Supreme Court, there are totally they made out 14 points on Article 14. That they should be followed. So you have to say that how Article 14 is applicable and the other side have to say it is not. What is your article? There is too much of legal research and too less of serious thinking. Anyone, how is the list of cases there? Who has done this? Yeah. Enka is 7 years, not 6 years. Yeah, it is 7 years. Much of this. And then Ajay Asi also, I think, is 5 years, not 4 years. And Ajay Asi has an article 12 where they said for the first time. Another issue was whether the reputation will lie against the university. That was Ajay Asi. That was started changing in 75 whether public corporation and reputation will lie on. Because here the it is not filing in the state. Now it is very well settled after Ajay Asi, all those critical institutions. And I don't know how vulgar is there. What is right private argument? Vulgar tale. You have to read facts. Don't continue to apply law or get research without facts. Otherwise you will mess up. Particularly when you see that
No, actually, at least we are, I may say, we are convinced that they are wonderful people. I mean, at their age, I did not know anything. So they will be wonderful lawyers. They have done better than many of the brilliant lawyers here. And the kind of difficult questions we have put, and they have answered and tried to play with it, that's very good.
I remember it all these things are there.
My Professor Bakshi used to say, don't try to mug up the law. It's a toy, play with the law.